Today, we are going to be talking about debt and forbearance. I'm really excited about this panel. We have two panelists with us, Kelly Jones and Christy Downs. We will first hear from Kelly Jones and then Christy Downs, and then hopefully we'll have a few minutes for questions. So I'd like to first introduce Kelly Jones. Kelly Jones manages its own solo law practice in Portland, but partners often with other firms, principally as a team member of an underdog law office. Kelly is a civil litigator with a focus on consumer protection, civil rights, and class actions. Kelly's advocacy includes drafting legislation, pro bono representation, and appellate work. Over the years, Kelly has authored numerous articles and has given presentations on various consumer law and civil litigation topics. Kelly is a proud member of the Oregon Trial Association, Lawyers Association, and the National Association of Consumer Advocates. And he was awarded with its Rising Star Award in 2022. Christy Downs is a finance PhD student in the Lundquist College of Business at the University of Oregon and a certified defense financial manager. Christy has over 18 years of experience across a wide range of planning, resourcing, and education functions. She's led diverse teams sized from 2 to 400, directly managed annual operating budgets of up to $1.7 billion, and successfully grown a multi-state real estate business. Christy has served organizations in the Republic of Korea, throughout the United States, and during 2 deployments in Afghanistan. She holds a Bachelor of Science in Psychology from the United States Military Academy, a Master of Science in Finance from the University of Michigan, and a Master of Professional Studies in Legislative Affairs from George Washington University. So please help me welcome our panelists, and we'll hear from Kelly Jones first.
Thanks, everybody. So, when I was asked to speak about debt, I said, well, geez, about 15 minutes on debt, right? I've given 2-hour presentations on just, the FDCPA, the Fair Debt Collection Practices Act. So it's obviously hard to talk about debt from a consumer protection standpoint in that. And so I prepared some slides and data and things like that. But, I'm not going to talk much about it because it's a small group and I don't want to cut into Christy's time. You heard her resume, makes mine look every week, and you want to hear from her, mostly. And so really what I want to say, I think about that is, I think some stats are important. I don't know what the audience has completed. I see some friends and comrades, consumer lawyers, and I think, maybe we have some lawyers, some law school students. We obviously have some grant recipients that are interested in consumer protection, have done some research. And so, at what level do we need to explain? Well, I think some stats are important. Why is that important when we talk about consumer debts? Because, a lot of people are living in the shadows. This happens. People are embarrassed. People are ashamed when they have debt. So they don't often discuss it even with other family members, with friends, etc. And so a lot of their stories, go unnoticed. And so I think some stats that are just kind of interesting. Let's just start off debts. We're talking about consumer debts, obviously. So we're not talking about business debts. 2 main types of debts, like secured debts. That's their car loan, that's their house mortgage, things that have a lien on it that they come repossess if we don't pay it. They give you the loan, we'll take the property back. And there's unsecured debts. Credit cards primarily. We got student loans, scary word inside of a law school or university. Medical debts, payday loans. So according to the Federal Reserve in 2020, 2021, Americans own 10.49, so $10.5 trillion in debts. And about 4.15 trillion of that was not housing debt. So the student loans, the auto loans, the credit cards, etc. So we're talking about obviously a massive amount of debt. The most common debt, according to CFPB, that is in collections and is past due and they're collecting on is medical debt. And that's sad, isn't it? I mean, somebody experiences an illness or a family member experiences an illness and they don't have proper health insurance coverage, etc. The rate pursuit of these debts. and about 64 million Americans, as of 2021, had at least one derogatory account on their credit report that was being reported. And there's a common, stigma, obviously, with owing debts. Often, people that owe debts are called deadbeats, but that's not what the studies show. Actually, that there's, a significant amount of people that owe debts are out there purposely going into debt and not paying it back. What studies show is it's often, unexpected happenings in life, whether it's a medical, whether it's an illness, whether it's a divorce, whether it's a job loss, etc., that was unexpected. And we also see that with debt collection, there's obviously a real strong correlation with other socioeconomic factors and justice factors. People who live in certain neighborhoods, and people are of color that don't have health insurance, lesser education, etc. Those are the most likely people by far to be subject to debt collection. Debt collection is a known risk factor for depression, suicide, substance abuse, mental disorders. Obviously, puts strain on relationships. And so when Jennifer said she's excited to hear about this, this is fun. Those aren't necessarily fun facts. Who do we have in this process of debt collection? So we have the original creditor. That's someone who extended the loan, whether it's the bank or the attorneys that represent the debt collectors, especially the debt buyers, like the Portfolio Recovery Associates, as I mentioned, is a huge debt buyer, and they sue a lot of Oregon consumers. And there's one attorney that represents Portfolio Recovery Associates. He's not even in Oregon anymore. He's licensed here. I happen to go to law school with him, but he's in Chicago now, and he has the entire West Coast portfolio. And he one attorney signing all those documents. Do you think there could possibly be any sort of meaningful review? And there's one attorney that's filing in charge of the entire West Coast, including California and Oregon, filing all those lawsuits? Of course not. And so when we get to the consumer protection part of it, I'm not going to go into detail on this, but the main ways, and that's where I come in, and that's where consumer protection comes in, that's where our statutes come in, that's where our DOJ comes in. But at the federal level, in terms of administrative enforcement, there's the Consumer Financial Protection Bureau, the CFPB, that's in its portfolio now to pass rules and regulations and whatnot under the Fair Debt Collection Practices Act. Sadly, another not so high point is there's a case right now. Well, it went through the Fifth Circuit, and the Fifth Circuit said essentially that the funding was unconstitutional for the CFPB in the first place, so it shouldn't even exist. And now I think they heard arguments in the Supreme Court like in October, and I didn't follow what happened there, but we may not have CFPB too long. And so that sort of the onus, I guess, the bright spot I want to sort of push you on that, or at least something that we need to do, something I feel hopeful about. So we have state protections, right? We have the DOJ and AG Rosenblum talked a little bit earlier about some of the work that they're doing, not specifically in regard to debt, I think, but they have. And there's a case called Gordon v. Rosenblum that the AG's office sort of tangled with the largest debt collection law firm in the state, at least the most ubiquitous, Daniel and Gordon. It's now called Gordon, Aylward, and Tam EPC. That's in Eugene. And by the way, in Eugene, you also have, I think, the largest third-party collection agency was also located in Eugene, called Raycline Inc. or Professional Credit Service. So there's some roots to debt collection here in Eugene. And so our state statute to regulate debt collection, so you have the federal, the Fair Debt Collection Practices Act. And then we have a state little mini version called Oregon Unlawful or Unfair Debt Collection Practices Act, or a 641. It's a private cause of action. So given what's going on at the federal level, which we don't have time to get into, it's even more important that our state protections are strong. The problem is that our state act is not so good. And our debtor exemptions, so when a debtor gets sued and the debt collector is going to go collect the debt against them, wage garnishment, potential foreclosure, our exemptions are low. We are regularly getting failing grades, D grades, from national consumer groups on our debt collection law. Our state debt collection law has several problems. One is in civil rights statutes and the Fair Debt Collection Practices Act, there's something we have fee shifting. It's a private attorney general statute, it's known as, and that's because it was adopted and there was a private cause of action put in, so that can be privately enforceable. So that wouldn't just be the state or the federal government, in that case of the FDCPA, enforcing. What's critical to these statutes, just like civil rights statutes, is these fee shifting provisions. And what that means is, if a consumer in this case brings a case that, and if they prevail, yes, there's attorney's fees, but if for some reason they don't prevail, then the defendant doesn't get their attorney's fees unless they filed it in bad faith. Right? That's super important, because if I come to you or a family member came to you, so they talked to an attorney like myself and they said, well, they said I had a good case, but the statutory damages, $200, $1,000, the violation is clear, but he told me, as I have to do it, all to do it, well, there's a risk that that if we could lose on a technicality, we can't control that, we can't guarantee anything. And then the consumer says, or your family member says, if they tell you this conversation with player says, well, what is that? What would it mean if we lost? You could potentially be on the hook for the defendant's, corporate defense legal fees could be, $50,000 to $200,000. And I say, so listen, so I may get $1,000, to stand up, enforce my rights under this act, but there's a chance I could, be out $200,000 if we lose, and I might push myself into bankruptcy. So no one's you wouldn't tell your grandmother or your mother or your friend probably go ahead with that kind of risk. So it essentially eviscerates and chills enforcement of that. We have Unlawful Trade Practices Act. That's a sister statute to the Unfair Debt Collection Practices Act in Oregon. We have that fee shifting, right, in that 646 for a reason. And so one more last thing, just to finish up, we need to make that change, and we need to change our exemptions, which are very, very low. We're in the league right now, family grades from the states like Mississippi and Arkansas. We've been trying to do that. We have good partners that are working in Oregon Consumer Justice now, and the unions and legal aid, etc. We didn't pass it last session. If you hear about it, last session was called HB 2008, and in this session is, I think the long name is the Oregon Family Financial Protection Act. And so, we'd like your support in that, whoever you are, in whichever way you can help in the next session on that. And now I'm going to pass it off to my new friend, Christy.
Hi. My name is working okay. Oh, so you don't have to use this. I'm a finance person, so there's no good without some charts and graphs, right? So I'll quickly pull this up so that you can see. I'm also, from an accessibility standpoint, I'm a visual learner, so I like to have things to look at. That helps me a lot. And I'm a she/her when we're asking questions later. I'll be very brief. And then hopefully we'll have time to engage with you all and hear some of your questions. So I am a proud and very thankful recipient of grant funding. I know there's some folks on Zoom. Hello. I'm a proud recipient of this grant funding, and it's been very helpful for research. I am at the very beginning of the process. I am just starting my second year in a 5-year PhD program, and just got the data, which is funded by this research a couple weeks ago. So I'm pretty pumped. I've done a lot of theory work, and I'm going to talk to you today and hopefully help level some bubbles and share some information about why this is a really important topic and maybe some ways that I can help contribute a bit. So home ownership, big picture, is associated with long-term wealth building, and it's upheld as a method to improve some of the wealth inequality that we see for historically disadvantaged populations. However, maintaining that ownership, especially in volatile markets, can be very difficult
for exactly the populations that we're trying to help, those that are low wealth and don't have some of the financial cushion to support them when they lose a job or have some sort of temporary income shock situation. So my research is focused on one protection from the CARES Act that was aimed at exactly this: mortgage forbearance and helping people weather the temporary financial storm associated with loss of job or lost hours when COVID hit. That's big picture. Okay, so why does homeownership matter? Why is this important? And I'm sure this audience is probably very familiar, but there's a long and storied history about some of the policies that the US put into place that were horrible, like segregation, and some of the things that had horrible unintended consequences with good original intentions, like some GI Bill advantages after World War II, helping veterans get homes when they came back from the war, but unfortunately, or fortunately, but unfortunately for this, many of those veterans, due to some other policies that we had, were mostly white males. And so, great, let's help veterans get houses. That's wonderful. You think that's a great policy, but unfortunately, that while advantaging those populations, created the unintended consequence of disadvantaging anybody that wasn't a white male veteran. It made it much more difficult for homeownership for those populations. Fast forward to today, or a couple years ago with the census data, and the median Black and Hispanic households had less than 10% of the net worth of the median white and Asian households within the United States. And the majority of that home equity for the median household in the US in 2019 was $130,000. The far distant after that was retirement account balance, which was close to $70,000 for the median household. So home ownership, household wealth really is household wealth within the United States. And so that's important. This is an important, home ownership matters from an equality perspective. It also matters for the individual consumer and wealth building. Houses, we used to think, the research community used to think houses were a consumption good. It's just something you get, like going to the grocery store, you need housing, you need somewhere to live. But we've learned through a lot of research that houses are also a financial asset contributing to individual wealth. And from a society's perspective, why does society care about making sure some of our most disadvantaged individuals become homeowners? It's really cost effective from a policy standpoint because you have essentially a small infusion of in the form of tax credit or help with a down payment, or just saying you only need a 5% down payment versus a 25% down payment. Some of those policy changes that can be very cost effective, when you magnify that across time over generations, that has really huge long-term outcomes for changing a family situation. And so big takeaways from here: assets bring wealth, bring opportunity, it's magnified across generations, and unfortunately, there is a significant racial divide within the United States about it. Okay, so homeownership, great. Path to closing wealth inequality, or is it? So some groundbreaking research after the 2008 crisis, the Great Recession, is that what we actually found was it can cause some pretty negative consequences when folks aren't able to sustain the asset. So up until that point, people thought, policymakers thought, great, we'll help with asset attainment, and then you're good to go for the next several generations. Good for you, you've attained the asset. But what we saw was when there was a huge glut of foreclosures, 4 million foreclosures plus or minus in the Great Recession, was that those that were not able to hang on to their home during that temporary financial storm, they couldn't weather it, actually saw an average loss of 39,000 median net wealth compared to those that were able to sustain the asset, saw an increase of 110,000 net wealth at the end of it because house prices recovered, etc. And so what we found is it's not just about asset attainment, it's also about asset sustainment. We need to help people weather that storm. And so fast forward to the next major national crisis. We learned from this and implemented some great policies in COVID. And one of those policies was mortgage forbearance. And I will talk about that in the next slide. So what is mortgage forbearance? I'm not sure how many people are homeowners or have dealt much with the mortgage world, but mortgage forbearance is essentially the mortgage lender allowing the borrower to temporarily pause payments. And the important thing is it doesn't affect their credit score. There's no fee associated with it. They're not penalized in some financial way for doing this. So it's just essentially a scaffolding to help them get through a temporary income shock so that they can keep the asset and it'll help them long term. The repayment method varies. You can have lump sum at the end, and it's typically based on the individual's either choice or the individual's financial situation on the other side of the forbearance period. So lump sum, if you can essentially self-cure, it's called. You can add balance to the remaining monthly balance for your future payments, or it can just get tacked on to the end of the loan. If you had 30 months left on your mortgage and you paused for 6 months, then you have 36 months left on your mortgage. Just literally pauses and you resume it for the same contract period that you would have done. Really importantly, from a policy perspective, it is not loan forgiveness. There's no write-off to the lender. There's no repayment by government funds, which we saw a lot of in the rental space during COVID. There was a lot of government funds where you literally just paid the rent. So this is, from a policy perspective, not quite cost neutral, but very cost effective. Forbearance is not a new policy tool, but ease of use matters. So in the 2008-9 crisis, there was a similar program called the Home Affordable Modification Program, HAMP, and it was only taken up by about 1.3 million users, even though, like I said, there were 4 million foreclosures. And essentially, the paperwork burden was pretty high. You had to prove that you needed it. You had to fill out a lot of forms. Everybody had to agree to it. It was a really taxing process. And so what they found is a lot of people just didn't do it and ended up going into foreclosure or didn't know about it. And it was just so troublesome. Whereas during the CARES Act, essentially you just, I'm not sure how many folks had an online service word, but there was a big banner across the top of just about every servicer's page where you could click here if you need some help, etc. And we saw a take up of about 1.5 million users. And some of those users didn't need it, didn't end up losing their job, did it as kind of protection just in case. I'll keep it if I need it, and didn't end up using it. But a lot of people who really did use it, really did need it, and it helped. So fast forward. Where we are now. So what we know, and the Federal Reserve has almost infinite resources of research, and they have done some incredible analysis, but it's mostly focused short term, the national impact of forbearances. And like I said, I love charts. So the one that you see here with white and purple, essentially equates to people percentage of the minority share in a zip code. So the more purple, the more minority in a particular zip code across the United States. And so what this chart shows is that, and this was from May of 2020, is that not shockingly, a lot of people needed help. And typically, the people that needed the most help were the people that were living in zip codes of high minority population. And then what we saw for communities, and the other chart that shows 2 lines and a bunch of dots shows home price stability for communities in the 2008-9 crisis and in 2020. And what you see is it's compared to unemployment. And so what you see is a really negative trend for community home prices in 2009 when the protections didn't exist and people were losing their homes kind of en masse, and especially the most at-risk people that couldn't weather those temporary financial storms were just losing their homes in mass, which was causing a supply and demand cycle where I didn't lose my home maybe, but the person next to me did, and then my home value drops too, because now it's an unoccupied property for the next 3 months, with boards on the windows, whatever else. So it had all sorts of negative consequences, not just for those individual homeowners, like I mentioned, but also for the community at large, because it drove home prices all over down. And then on the top, you see helping with that temporary protection, essentially. As anybody that reads the news, home prices stayed pretty stable during this crisis. So, where my research comes in. So we know a lot about the short-term national impacts, but what we don't know is how that affects us, how that affects Oregon consumers, and if those national trends in any way even relate to the individual, right? So there's significant mortgage heterogeneity, like very, very, very different for what might happen in Louisiana, what might happen in Chicago, what might happen in rural California, and Oregon has unique needs. And although we know what happened in the short term, we don't know how this plays out long term. We don't know if potentially it was just a delay of these foreclosures, and maybe people got used to not having to make their mortgage payments, and then there's still foreclosures, a big glut of foreclosures, just kind of a little bit further down the pipeline. And so that's what I'm getting into. That's what I'm digging into, finding out the more long-term effects of this once this forbearance policy wore out, and then the foreclosure process takes quite some time. How that plays out for Oregon, and then how that plays out long term. So, like I said, I just got the access to one portion of the data that's really critical to this, the mortgage performance, a couple weeks ago, and I'm really excited about digging into it and finding some of these answers. Format.
So I am standing between you and lunch, but I'm going to suggest that we spend 5 minutes with a few questions, and if there is some time to get lunch, and I am supposed to let people know that you're welcome to take your plate with you to your next session if you don't have enough time. But I'm going to suggest that maybe we do have a few questions before we pause. I'm going to ask if anybody has a question to ask it. I'm going to repeat it so we can get it on the Zoom. So questions. Professor Tippett.
Question for Kelly. Do you think like the presence of these large debt collection companies in Eugene is a function of the state laws? Like, are they especially favorable for debt collection, or is it just coincidence that they're here?
So there was a question about the location of debt collection agencies in Eugene and how that might relate to law.
Yeah, Professor. So I guess I didn't mean to say, there's these massive debt collecting companies and all, hovering around Eugene or Oregon in general, but just coincidentally, I think, perhaps, the largest debt collection law firm in Oregon, it's now Daniel Gordon's old shop, rest in peace, Daniel Gordon, who's no longer there. And also, for some reason, also the largest third-party collection agency, Rick Klein, that happens to have its headquarters in Eugene. So when I talk about debt buyers in general, most of those they're not here, right? They're these big corporations like PRA, portfolios out in Virginia, and they're drawing a lot of money out of Oregon from when they sue our consumers and they sue our debtors, and they're garnishing their wages, etc. So a lot of that money's not staying in Oregon, that's getting drawn out, and they're all over the country. So it's not like they're attracted specifically to Oregon consumers. But I will say, and that was the end part of my speech, that our state debt collection law really needs to be revamped. And so some of the practices that they're engaging in that, we could maybe sue under our state law, we can't. And it's not just the problem that I said with the fee shifting. There's other problems that need to be amended from bad court decisions from a long time ago that really hamstring us to be able to use that state statute that we use today. Thank you.
Other questions? Yeah.
Kelly, you briefly alluded to Porter versus Hill. Can you briefly describe that case and propose a legislative fix to get around it.
So more information about Porter v. Hill and the legislative fix to get around it.
Yeah, thanks. And that's Justin Baxter. It's you know, he and his dad, Michael, who's now retired, like pioneers in Oregon in consumer protection. It starts the Fair Credit Reporting Act, but they do debt collection cases. And I consider him one of my mentors too. And thanks. And so, yeah, I mean, we've done that, and I say we, it's I helped draft, but you know, it's a partnership. In that HB 2008 that I was discussing, the Oregon Family Financial Protection Act that we're going to bring in the next session that didn't get passed, like a lot of stuff this last session due to reasons that if you're paying attention, I think you'll understand. But yeah, the language in there that I drafted, I mean, without being you know, too specific, is basically to just create a new subsection or rework a subsection to get around all of the sort of terminology that were in the other little subsections that Porter v. Hill touched on, and even specifically have language in that subsection that negates that, if that makes sense. Because the Porter v. Hill problems, the way I see it, there's two, and it's from a Supreme Court case called Porter v. Hill. There's a progeny of cases that were decided based upon that affected all different subsections of the OECPA. And one, if somebody's collecting a debt on a debt that's not even owed, somehow that's not a violation of our debt collection practices statute. That's a reading of that case essentially, and that's been held down. The other thing is, if it even smells of any sort of litigation, then you don't have a claim. And so, meaning if the debt collector commits a violation, even when they're sending a letter saying they're going to sue you, or at any point during after that, you don't have a claim, most likely under that statute. And so those things need to be fixed, because a lot of the violations that happen obviously are in the process of a debt collector suing you or when it goes to court. And I guess just a quick thing on that, the way the court thought about that back in Porter v. Hill was that, well, the legislature didn't mean that, because once you get sued, the court will figure it out. Like the state court will figure it all out, and they'll protect you, and you'll have options in there and stuff like that. Well, as I mentioned before, I mean, with inundated with debt collection, the court doesn't have the time, resources, or it's just not how it works that they're going to oversee that process and provide any protections.
So I'd like to have us thank Christy and Kelly one more time. I'm guessing they'll stay around if you have any more questions, and we'll reconvene after our lunch break. So thank you so much.